Oftentimes when people find out that we're DUI attorneys, people ask the question about sleeping in the vehicle, and they think, well, if I sleep in the back seat of the vehicle, as long as I'm not in the driver's seat, as long as the keys are not in the ignition, I can't get arrested for DUI. I'm not driving the vehicle. That's not true, is it?
No, it's a complicated analysis because what the officer is looking for is, could you have put that vehicle in motion? Tennessee has a very strict standard when it comes to DUI. So just because you're asleep in the back seat doesn't mean that you can't put that vehicle in motion. You know, we've talked about in old videos, you know, whether or not you have a push button car or whether you have the keys in your pockets, right? If you have the ability to make that vehicle operable, then you can be said that, hey, you're in control of the vehicle for the purposes of the statute.
Right, and it's a case-by-case basis, obviously, about whether or not we can convince a prosecutor or a jury whether or not you were in physical control, whether or not you had the intent and ability to exercise control of that vehicle. There's also a policy argument as well that we talk to prosecutors often about, depending on where they're parked, right? So we have clients who are parked in a parking garage. They have no intent to drive the vehicle. Technically, they may be in physical control of the vehicle as they're sleeping, but it's not necessarily a good policy to say, hey, that's against the law, we're going to convict you of DUI. The public finds out about that, and you're telling people, take the chance, drive your vehicle impaired, because maybe you get home okay and maybe you don't get arrested for DUI. Yes, you might injure or kill someone driving that vehicle, which is why we do not want to set that policy standard. But they're kind of telling people you have a better chance of getting home without a DUI by getting on the streets and driving than falling asleep in a parking garage and having someone call 911 that you're passed out behind the wheel. So there's a policy argument against, disallowing people from sleeping in their vehicle. But there's also a potential necessity defense that we argue as well, right? So people talk about, well, if the keys aren't in the ignition, I'm not in physical control. But we're thinking of, freezing cold temperatures outside, and people have their vehicle on when they're sleeping because they need a heater, or it's hot out. Right now it's 95 degrees this past weekend. I went to a Smokies game with my family. 95 degrees out. You probably need your AC on, right? So there's also a necessity defense we can argue as well.
Absolutely. It's one that it's not as cut and dry as it would sometimes seem, but it is one that there's going to be a variety of defenses that can come up. Obviously, the safest option, Uber, call rideshare, something like that, but it's one of those that, like Brandon was talking about, the policy argument is that you should not be risking it. So it's one that ultimately, if you do have to sleep in the car, maybe give your keys to somebody else after you get the door open. But if you have your keys on your person, you could be found guilty of a DUI for being in control of the vehicle.
Right, but that's why it's so important, again, for your DUI attorney to talk to the prosecutor about the policy argument, talk about the case in its entirety and what your intent was. Any text messages, any proof that you called an Uber but fell asleep, maybe the Uber got there and you were asleep and it left you there, right? Those are ways to show that you did not have the intent to exercise control of that vehicle and drive that day. Unfortunately, the law is not great for this issue. There's a case by the Tennessee Supreme Court where a vehicle is out of gas and the defendant argued that it was inoperable. So whether the vehicle is operable is also a factor. In that case, the court decided, well, just because the vehicle is out of gas, it doesn't make it inoperable, because you can walk a mile to a gas station, get a gallon of gas, walk a mile back, whether you're unsteady on your feet because you're impaired or not, fill that vehicle up with gas and then drive and still be under the influence. So as far as the vehicle being operable, they're looking at, is the engine completely fried to where you cannot move that vehicle at all versus something that could be fixed. So, you have a flat tire, they're going to try to say it's an operable vehicle. If you're under the influence, you're probably not able to take that tire off and put on your spare. But, again, that's why it comes down to the technicalities of DUI law and then the advocacy to convince a prosecutor or a jury that, they can't meet the elements because it just doesn't make sense. They can't have it both ways. It's either you're too impaired to operate the vehicle or you're not. And if you're too impaired to operate a vehicle that needs a spare tire, you're probably not in the right state of mind to change that tire. So a lot of things that we need to look at and evaluate in DUI cases.